Good morning, everyone. Today we will discuss the Nevada state government's judiciary. We will cover topics such as the creation of an intermediate appellate court, the qualifications for the NV Supreme Court, and the ways in which justices are appointed to panels. Let's get started.
Nevada's state court system is separated from the federal court system, with each state having its own court system that makes decisions based solely on state law and cannot be intervened by federal court. Nevada was, until recently, one of the few states without an intermediate court of appeals between their Supreme Court and trial courts. 4 attempts to add the intermediate court have been rejected by citizens in a vote. The attempts to add the intermediate court was to reduce the workload of the state Supreme Court.
In 2014, citizens of Nevada passed a significant amendment to the state's judicial system. Consequently, an intermediate appellate court was established and began operating in 2015. The purpose of the court was to lessen the load on the Supreme Court, who were previously the ones hearing appeals from murder convictions to driver's license revocations. This innovative court has been able to lighten the workload of the Supreme Court, allowing them to focus on more serious matters. To learn more about its function, visit the court's website. The Nevada state government judiciary is discussed in this slide. The Nevada Supreme Court is the highest court in the state judicial system, with its decisions being final, except in cases involving federal issues. Elections for the Nevada Supreme Court have been nonpartisan since 1915, ensuring a fair and impartial setting for justice. An individual to be appointed to the Nevada Supreme Court must meet certain criteria. They must be at least 25 years old, a Nevada licensed attorney, have resided in the state for a minimum of 2 years, and have at least 15 years of legal experience since 2005. Initially, the Nevada Supreme Court had 3 justices. However, in 1999, the court was increased to 7 justices to enhance the state's judicial system. Nevada state government's judiciary is discussed in this slide. The Supreme Court of Nevada is able to hear twice as many cases as before, due to justices sitting on 2 panels of 3. The northern panel is based in Carson City and the southern panel in Las Vegas, with the membership changing every 12 months. The Chief Justice does not usually sit on a panel, unless one of the panel's justices recuses themselves from a case because of a conflict of interest. This system makes decision-making within the Supreme Court more efficient. Nevada state judiciary is the court system in charge of interpreting the state's laws and guaranteeing justice. It is composed of 7 justices who hear the most significant cases, such as those related to ballot questions, the death penalty, and the suspension or disbarment of attorneys. It is remarkable that the position of Chief Justice is a rotating one, which means that it is kept by different justices. Nevada State Supreme Court is the highest court in the state and is chiefly responsible for appeals. It has the ability to hear writs of mandamus, death penalty cases, habeas corpus, and disputes between 2 branches of government which cannot be amended without a constitutional amendment. This makes it a considerable legal authority in the state of Nevada. The Nevada State Supreme Court is the highest court of the state of Nevada. As an appellate court, the Supreme Court only has the authority to review questions of law. For example, if a confession was obtained illegally, and not questions of fact. Additionally, the Nevada Supreme Court cannot issue advisory opinions or hear cases that are considered moot. From 1955 to 1990, the volume of cases filed with the court increased by an astonishing 2,000%, with 4,164 cases filed in 1998 alone. That year saw a particularly high number due to the fact that the court had only 5 justices. Nevada state government's judicial system comprises of Supreme Court, District Court, and Municipal Court. Annually, the Supreme Court receives more than 2,000 new cases. These cases are heard in private by justices, and then majority, concurring and dissenting opinions are issued which resemble the ones from United States Supreme Court. Nevada's judicial system is composed of the Supreme Court and the Court of Appeals, the latter being made up of 3 elected judges, elected in a nonpartisan race with non-staggered terms. For the fiscal year of 2016, the Supreme Court received 2,452 appeals, with 637 assigned to the Court of Appeals for decision. In 2020, the Supreme Court and the Court of Appeals combined to address 2,124 cases, placing emphasis on the importance of the Court of Appeals within the state's justice system. Nevada's state government has the judicial branch as its cornerstone, which is entrusted with effectively making sense of the state's laws. NV district courts are managed by elected judges, chosen without any particular political party allegiance, to serve for 6-year terms. To qualify, they should have 10 years' worth of legal knowledge, the same as necessary for Supreme Court judges. It is significant to bear in mind that, unlike the Supreme Court, all district court judges stand for elections at once, and this is to ensure the fairness of the judicial system. The Nevada state government is dedicated to maintaining the highest of standards when it comes to justice. The Supreme Court, judicial district courts, and justice courts have been implemented to uphold the Nevada Constitution and protect the rights of the people. Judges that serve in these courts work diligently to guarantee a just and balanced judiciary system. It is evident that the Nevada state government puts in a significant effort to ensure justice is upheld throughout the state. In Nevada state government, a jury trial is the right in both civil and serious criminal cases. For criminal cases, the jury is responsible for making a decision on the defendant's guilt or innocence, with all of the jurors' votes needed for a verdict. Meanwhile, for civil cases, a verdict may be reached if 3/4 of the jurors agree. Nonetheless, the defendant may always decide not to have a jury trial and instead be tried by the judge alone. Nevada state government is structured into 3 branches, one of which is the Judiciary District Courts, are the courts of general jurisdiction in Nevada, and these courts have both original and appellate jurisdiction. Such courts are equipped to handle both criminal and civil cases, including cases with a value of over $15,000. Along with this, the state legislature has passed a law which necessitates that civil cases with a value under $5,000 must go through non-binding arbitration first. If no agreement is reached, the case is sent to the district court. Nevada state government has created a 3-tier court system to ensure that all Nevadans have access to just and fair judicial review of their cases. District courts are the trial courts of the state and preside over civil and criminal cases. These courts have the authority to issue writs, such as injunctions, habeas corpus, and writs of mandamus. They also have the authority to hear appeals of orders issued by state administrative agencies and appeals from municipal and justice courts. By providing justice at the district court level, Nevada state government ensures that all Nevadans have access to fair judicial review. The Nevada state government has an important role in providing justice to its residents. District courts are the trial courts in the state and have the authority to issue writs as well as hearing appeals of orders issued by state administrative agencies. Furthermore, they can hear appeals from municipal and justice courts. This 3-tier court system ensures that all Nevadans have access to fair judicial review. By having district courts closely tied to the Nevada state government, justice is served, and all Nevadans can have their cases heard. Nevada has a 2-tier court system, which covers minor criminal and civil cases. Townships select justices of the peace in nonpartisan elections for 6-year staggered terms. These justices of the peace are not necessarily required to be attorneys, although for counties with a population of over 100,000, they must have had at least 5 years of legal experience. Justice courts are established in each county of Nevada, excluding the city of Las Vegas, by the state legislature. These courts are responsible for hearing minor criminal offense cases, civil cases with a value of $15,000 or lower, and preliminary hearings in felony cases. Moreover, small claims court is a special division of the justice courts which addresses claims not exceeding the value of $100,000. There are also municipal courts established in each of the 18 incorporated cities to handle traffic cases, cases of the city recovering expenses of $2,500 or less, and violations of city ordinances. Nevada state government operates the judiciary system throughout the state, with municipal court judges elected in a nonpartisan way and served 6-year staggered terms. The only qualifications for municipal court judges are that they must be citizens of the state, a resident of the city for 1 year, and a qualified elector. although certain cities may add additional qualifications, such as requiring municipal court judges to be lawyers. In some less populated areas, such as Fernley, the municipal court judge may also serve as a justice of the peace. Thank you for listening to this presentation. It is hoped that it was helpful in understanding Nevada state government's judiciary system.